I'm Jamie Markham from the UNC School of Government, and in this video I'll explain how Aggravated Level 1 DWI sentences are served in North Carolina. As you may know, in North Carolina, impaired driving is not sentenced under our regular structured sentencing laws. Instead, it's sentenced under its own rules. They're set out in Chapter 20 of the General Statutes, and they're summarized on this chart that was prepared by my colleague Shay Denning. The chart is available, by the way, in the sentencing handbook that Shay and I have put together. And what you can see on the chart is that there are 6 levels of impaired driving, all the way from the least serious level, level 5, all the way up to the most serious one, aggravated level 1, which we'll be talking about today. In a previous video, I talked about how sentences are served for the lower 5 levels of DWI. Those are all served under essentially the same rules, but as we'll see in this video, aggravated level 1 sentences are different, they are administered differently, and so we'll treat them separately. And what we're going to be focused on here is how an active sentence for aggravated level 1 DWI is served. As you can see, it is possible to get probation for an aggravated level 1, and the rules for that are included in the chart, but we're going to be focused on how an active sentence is served. So here's the statute that sets out the punishment for aggravated level 1 impaired driving, and what you can see in it is that the sentence must include a minimum term of not less than 12 months and a maximum term of not more than 36 months. Those are the longest punishment periods for any type of misdemeanor impaired driving, but the statute then goes on to say, unlike other types of DWI sentencing, that defendants sentenced under this law are not eligible for parole. Now, if you've watched the previous video about how level 1 through level 5 DWIs are administered, you may remember that in that video I expend a considerable amount of time talking about how parole works for them, how the minimum sentence its sole purpose is to dictate when the person is eligible for parole. Also spend a fair amount of time talking about the effect of good time credit and how that operates to cut DWI sentences in half. So in a sense, aggravated level 1 sentences are easier in those because the defendant is not eligible for parole. You don't have to go through all that complicated math. That may, however, have you asking, why is there a minimum sentence at all if there is no eligibility for parole, if the whole purpose of the minimum for those other sentences is to tell you when the person might be eligible for parole? It's a good question. In fact, it's a question that the Department of Public Safety posed to the Attorney General's office not long after the law was passed, looking for help in understanding how the Department of Public Safety, how the corrections system was supposed to administer these sentences. They weren't even sure, with a 36-month maximum, they weren't even sure whether this was a felony or a misdemeanor, and with no parole, they weren't sure how they were supposed to administer the minimum sentence, what its effect would be. And if you look at the reply from the AG's office back to DPS, what you can see is they say, first, that it is a misdemeanor, and as for the effect of the minimum sentence, they say that if there's no eligibility for parole for this level of impaired driving, then the minimum sentence is essentially without any effect at all. In fact, they say that the trial court need not even impose a minimum term because it doesn't have any impact on the administration of the sentence itself. Interestingly, the letter also says that because the legislature excluded these aggravated level 1 sentences from parole, that also showed a legislative intent that no sentence credits would apply in these cases. So things like good time, gain time, merit time, the credits that I mentioned in the other video that serve to cut other DWI sentences in half, they conclude that none of those credits, no sentence credits of any type, are available for aggravated level 1 impaired drivers. It's not crystal clear to me that those two things go hand in hand. I mean, you could still have the credits applied to determine the person's outright release date and not their parole eligibility, but nevertheless, that is the way the law has been interpreted since it came into effect, And that's why, as we'll see in a second when we work through some examples, that aggravated level 1 sentences are not cut in half. So let's go back to the statute here and look at how some of the more common sentences for aggravated level 1 DWI actually play out in practice. So remember, it has to have a minimum of not less than 12 months and a maximum of not more than 36. Let's start with what's probably the most common sentence for defendants convicted of impaired driving and sentenced at aggravated level 1. Honestly, probably the most typical thing is that you get the longest possible sentence. Remember, these are serious cases involving repeat impaired drivers for the most part. And so many times they'll get the longest sentence they could get. That would be a minimum term of 36 months and a matching maximum term of 36 months. And as far as the place of confinement for that, we know that it'll be the statewide misdemeanor confinement program. That is the proper place of confinement for any impaired driver, regardless of sentence length, for a sentence imposed after January 1st of 2015. So let me move that up out of the way a little bit, give us a little bit of room, and also bring in the statute, which is 20-179F3, and that tells us the punishment for aggravated level 1. And then maybe give ourselves a little bit more room here so we can set our 36 to 36 month sentence out on a timeline from 0 all the way to the maximum of 36 months. Remember, our minimum sentence is also 36 months, but based on the interpretation that I talked about before, the minimum essentially has no meaning. There's no parole, and also based on that interpretation, there's no good time credit or any other credit to be applied, so the sentence doesn't get cut in half. So when does the defendant get released? Well, if we look back at the statute, what we can see is that it tells us when the person is released. The defendant shall be released from the SMCP on the date equivalent to the maximum less 4 months. So for us, that's 36-month maximum minus 4 months is a release point of 32 months. And at that point, the person is released to be supervised by the section of community supervision of the Division of Adult Correction, that is probation and parole basically, and the person is subject to the provisions of Article 84 of Chapter 15A, that is post-release supervision. The statute goes on to say that that period of post-release supervision is 4 months, and the person's on PRS for 4 months, with these remaining 4 months of imprisonment hanging over their head in the event of a violation. Those violations are heard by the Post-Release Supervision and Parole Commission in Raleigh, and if the person violates, they could, in some cases, be brought back to the statewide misdemeanor confinement program to serve those final 4 months. So aggravated level 1 DWI is the only misdemeanor in North Carolina that's subject to post-release supervision. You can see why initially the prison system may have been asking, is this a felony or a misdemeanor? We're not sure what to do with this. But it is a misdemeanor that gets this unique 4-month term of PRS. And this type of sentence administration here, if there's a 36-month maximum, the sentence is going to be administered the same whether the minimum is 36 months, whether, you could imagine if the court imposed a 12-month minimum with a 36-month maximum. Because there's no parole for these, the minimum has no effect. The sentence is going to be administered the same way. If it's a 12 to 36-month sentence, the person's going to be released at 32 months to be on post-release supervision for 4 months, with those final 4 months hanging over their head. Now notice that the maximum sentence doesn't always have to be 36 months. It just has to be not more than 36 months. So you could impose a maximum sentence of as little as 12 months. That's the floor that you can't dip below. So what happens then, as a sort of a final question to think through, is what happens if the court imposes the lowest permissible maximum sentence of 12 months? That would look something like this. Again, it's impaired driving. It's aggravated level 1. The minimum can't go below 12. Let's say we do a maximum of 12. Again, it's going to be in the misdemeanor confinement program regardless of length. How is that going to be administered? Well, if we bring the statute back in and then draw our 12 to 12-month sentence, 12-month maximum, and also this 12-month minimum out on a timeline. We can look at how this would be administered, look back at the statute and say, it's not crystal clear what's going to happen here. It says you've got to serve at least 12 months, but then it also says the person shall be released on the date equivalent to the maximum less 4 months. So it wasn't clear initially when this law came into effect how it would work if the court imposed this sort of lowest permissible maximum sentence. In fact, what they've decided to do is if a person gets this type of sentence, if they get a 12-month maximum sentence, they will give effect to the post-release supervision provision. They will release the person 4 months before their maximum sentence, which in this case would be 8 months, and the person will then be on post-release supervision for 4 months with these 4 months of remaining imprisonment hanging over their head. If they violate post-release supervision during that 4-month supervision period, and the Post-Release Supervision and Parole Commission finds a violation, they could bring the person back to the statewide misdemeanor confinement program to serve what's left of those 4 months. So that is a summary of how active sentences for aggravated level 1 DWIs are served. As always, if you have any questions or you'd like to talk more about it, please reach out to me at the School of Government. Thanks.